So this unit will talk about IRS appeals and US tax court. So basically, uh, IRS having different, bodies, like IRS having different divisions, I can say. So IRS divisions, which were first one, IRS divisions. The first one, examination, which is audit division. Examination, which is audit division. So this audit division, what they will do, uh, like whenever they feel, whenever IRS feels that there is something suspicious on the tax return, they will send an audit notice and they will review the tax return and they will determine whether tax reported is correct or not. So that is what the examination department or audit division will do. And also in this we have one more division, which is collection division. So collection division collection division. So once the tax bill determined, so then the taxpayer need to pay the bill, right? So if taxpayer is not paying the tax bill, then division will collect the money from the taxpayer. So this is one division, and also another division which we have, complaints division. So this complaints division, they will ensure taxpayer follows the tax laws. So in every country, tax any laws are voluntary. So that means it is your responsibility to follow the rules. So that part, so the compliances department will take care about those compliances thing. So they will ensure taxpayer follows the tax laws correctly or not. So how they will do? So for compliance purpose, so they do have some checks and all. So they will match, like while we prepare the income tax return. So in that we have, let's say we have Form 1040, which is individual income tax return. So in that case, W2 taxpayer having wages statement. So when he filed his income tax return on the W2, he's actually having $100,000 income. But in the tax return, he had reported only 90,000. So that means IRS can see the difference of 10,000. In that case, the compliance department will send a bill. So this part will taken care by the compliances. Like they will ensure taxpayer follows the correct laws or not. And apart from that, we have one more department, which is division, which is IRS Independent Office of Appeals. So this appeal, this is within the IRS. So within the IRS, we have these departments. So IRS Independent Office of Appeals. That means they are independent from these departments. So that means they are under the IRS, but they are independent from these examination, collection, and complaints. If taxpayer, let's say we have a taxpayer had an issue with any of these department, then he can go with this separate independent, but it is also under IRS only, but it is independent from these examination, collection, and complaints. Like let's say we have a taxpayer, we have taxpayer Mr. TP, Mr. Mr. M. So he's having some issue with the examination division. So like let's say examination division or audit division had sent a bill to pay $10,000 tax liability, additional tax they're asking. So taxpayer have already paid $20,000, but still this examination department asking him to pay additional 10,000 by sending a bill. So in that case, what he can do? He can approach to this independent office of appeals. So what exactly the office of appeals will do? So they will check the facts and circumstances. That's it. So they will not see your emotional and they will not see your financial issues, nothing. So they will check the facts. So based on the fact, they will resolve the issues, which is, I can say, settlement department, which is informal. So usually if there is issue between these divisions, which is within the IRS taxpayer, if there is any issue with this examination department or collection or compliance department with the taxpayer can have right to appeal before independent office of appeals. So that is the process actually we have to follow. Okay, so now I think we are recording. Okay. So now tell me, what is IRS Independent Office of Appeal? What exactly it means? Which is independent of independent of examination, collection, and compliances, which is neutral administrative form, which is also administrative form only, which is but which is neutral. So what they will do? So they will majorly focus on settlement, not enforcement. So enforcement department. So the IRS will take care about enforcement. But what exactly Independent Office of Appeal will do? So they will focus on settlements only. So they will focus on settlements, and this is not enforcement, which means, it is by law. So they have complete right to, follow the rules. So this is not, enforcement department. This is a settlement department, I can say. So this is, uh, you know not enforcement. So they do work for audit, or they do work for collection department? No. So this is they do, work for both taxpayer, and also they work for IRS. So they will check the facts, and they also do fair and impartial things. So this is very important in the exam. So they work fairly and impartially. That means they will only check the facts. So this is important. And also and also how the taxpayer can approach to the appeal department. So for that we have two criteria. So how the taxpayer can approach to the IRS Independent Office of Appeal. So in that we have two categories. So one category, which is small case request, small case request, and another category we have formal written protest. So small case request, which means the name itself, it is saying the tax disputed amount between taxpayer and IRS, which is less. So which is less than or equal to $25,000. If there is dispute between taxpayer and IRS agencies, which is examination or compliances or any audit. So in that case, if there is difference of, tax liability, which is less than or equal to 25,000, then he can go with small case request. If it is more than $25,000, then he need to use the option of formal written protest. So this is amount is less, and also which is less formal, here less formal. And also no need to give complete detailed information, no detailed information. But when it is formal written protest, the name itself it is saying, so it is written protest. That too we have to use, which is large. This is used for more than $25,000, and also in this the taxpayer need to mention or include few items, which is issue being disputed, issue. So what exactly the issue? So everything he need to include in the formal written protest, and also he need to mention the facts, and also the difference you have, taxpayer having the difference, uh, right? So for that, do the taxpayer having any law supported? So supported by any law. So we have to give this information as well. And also, what is taxpayer position? So taxpayer, we have discussed this taxpayer position in previous topics, I think. So you can see if you want. Okay, so in the recording session, let me send you uh, the unit name after the session. And also, so this is how the formal written protest works. So in this case, what the appeal will do. So the independent office we have, right? So what they will do? So they will majorly focus on facts. So they will consider the facts, and also they will consider the evidence. Whatever the evidence the taxpayer having, they will consider those as well. And also tax laws. So they will only check the tax laws and facts and evidence. And also if there is any court precedents previously, so they will also check court precedents as well. and also risk of IRS losing in the court. So they will also check all these aspects. IRS risk of IRS losing in the court. They will consider everything. So because this is kind of settlement department, right? So they will check all these, and also appeal will not consider. So these are the points appeal will consider, and will not consider few items, few things will not consider. The first one, moral arguments. So even though taxpayer is not in a situation to pay the tax liability, so will they check their moral arguments? So no, not at all. So they will check only the facts, evidences, and tax laws and court proceedings, and risk of IRS losing in the court. So these only they will check. Moral arguments. They will not check any moral arguments, and religious objections also they will not check. Religious objections, and also any political views also they will not consider, and unfair arguments. So these are the things the appeal department will not uh, will not consider. And also whatever the appeal, so appeal what they will do, so they will the appeal department appeal. In this appeal we have taxpayer and the IRS examination department or collection or compliances department, right? So let's say examination department or audit department. So they will act, they do act like a bridge between taxpayer and examination department. And in that case, whatever the decision this appeal department is giving, that must be supported by tax laws. So that whatever the judgment they are giving, that should be that should be there in the tax law. So that should be supported by the tax law. So then only they can deliver the judgment. Without that, without any support in the tax law, so can they give any judgment? No, they cannot do that. So whatever the decisions they are taking, that should be supported by the tax law. So this wording is very important in the exam. Okay. And also, uh, so what exactly the appeal officer roles? So we understood the process, right? So in this, what exactly the appeal officer's role in this entire process? Role of appeal officers. So do they need to, work independently? So do they need to review the case independently? Right? So they need to review the case independently. And also, and also they will check the strength and weaknesses of both sides. So they will whatever the judgment they are giving, that should be supported by the law. And also they need to see all possible ways. So who is having complete factual information, everything. So they need to check all those. And also they consider settlement. They will consider the so majorly the department itself, it is settlement, right? So they will consider the settlements majorly. Settlement offers seriously. And also they usually avoid any litigation, like avoid litigations. So these are the roles of the IRS, I mean appeal officers. And also when they will approach to these appeal officers. So when a taxpayer can approach. So usually mm, like let's say examination department, we have examination department, what they will do. So let's say taxpayer filed the tax return, which is his individual income tax return 1040, and IRS feels that IRS would like to examine the taxpayer return. So let's say before that they have to send a notice to the taxpayer. Let's say IRS would like to examine Mr. A tax return on December 2nd. They will send a notice and they will examine the individual taxpayer, Form 1040. In that case, IRS will be having two options. One, IRS, if IRS feels that the tax return, whatever the tax return filed by the taxpayer, which is fine, then they will not make any comments. But if they finds any discrepancy in the tax return, like let's say taxpayer filed his tax return, and in that we have Schedule C, the Schedule C income, which is $100,000, and also expenses he had mentioned, which is $90,000, out of which some expenses IRS feels that which are not reasonable, or taxpayer don't have any supportings for the expenses. Like let's say in this we have meals expenses. So meals, taxpayer don't have any receipts. So in that case, what IRS will do? Don't have any receipts. At the time of audit, at the time of audit, the taxpayer should provide all the required document supports, right? So how many years taxpayer need to keep these documents? Like we have read, right? So in the record keeping, the taxpayer need to keep these supporting documents for a 3 years period, right? Do you remember this point?
Yes, Jay.
So at that point, taxpayer is unable to provide the receipts. So in that case, like let's say the meals value, which is 50,000, he had mentioned. After, like, this is subject to 50% rule only. So after allowing 50 percentage, so taxpayer claimed $50,000 as expenses, but he is unable to provide at the time of audit. Then what IRS examination department will do? So they will straight away disallow this $50,000. So this is as per tax return, but IRS will calculate separately. So this is as per tax return by the taxpayer and IRS. So this is as per IRS. So 100,000, and here they will report only 40. So 50,000 they will disallow. So balance here 60. So previously he had paid tax on 10,000, but now as per IRS, then taxpayer need to pay on $50,000. So for the 50,000, they will send they will send, usually they will send a notice. So they will, if taxpayer agrees for this, he can pay the amount. If taxpayer is not willing to pay the amount, if taxpayer is not agreeing, then he will be having he will be having one option. Like IRS will send in the same bill, IRS will send in the same bill, they will send one option. Option one, agree and pay the amount. Agree and pay the amount. And option 2, they will only mention. So in the same bill, option 2, they will agree, they will tell you, you have 30 days to approach to the appeal department, appeals. So you have to, in the same bill, they will send you, one is option 1, agree and pay the amount. Option 2, you you can approach to any appeal department within 30 days. If not, then he will lose this option to approach appeal. So like let's say taxpayer had received a bill on December 2nd. Okay, so taxpayer have received a bill on December 1st. In the bill itself, they have mentioned option 1, agree to and pay. Option 2, you can approach to the appeal department. So this is date of notice. So this is not the date when taxpayer had received. Usually when they generate the bill, so they have to send to the taxpayer, right? So via mail. So mail in the sense which is courier in India, like which is physical copy, they will mail to the taxpayer. So mail means which is physical mail, not electronic mail. So they will usually, IRS will send only physical mails. They will not send any electronic mails. So now IRS sent a mail to the taxpayer, and taxpayer received on December 5th. So we have 30 days period, right? So that 30 days from date of notice, not from date when taxpayer had received. So even though we received late, it doesn't matter. So we will be having 30 days period only from the date of notice, not from the date when actually taxpayer have received. So from here we have 30 days, and within 30 days you can agree or you can approach to the appeal. What if taxpayer hadn't, replied to the notice and haven't paid, haven't agreed, and haven't approached to the appeal? So after 30 days, what will happen? After 30 days, he will lose his right to approach to the appeal. So he will lose the right. So this is actually approaching to the appeal is a right. So after 30 days, he will lose the right to approach the appeal department. So he cannot go and argue in the with the IRS in the appeal department. Now what will happen? After 30 days, again IRS will send a notice of deficiency. Notice of deficiency. So in that case, again, that means this is first notice, which is proposed amount, proposed bill. So proposed bill, if you agree, then pay. If you don't agree, then we will meet in the appeal. So that is what IRS will say to the taxpayer. So first one, proposed bill, and second one, notice of the deficiency. That means you must pay. So here IRS on 50,000, like let's say taxpayer standing at 22 percentage, which is $11,000. $11,000 IRS is asking to pay the amount. Now, in the second notice of deficiency, they will ask you to pay the amount 11,000 directly. So they will not, you don't have any option. First one, they will ask you to pay the amount. Here also we have options. The first option, they will ask you to pay the amount, and also second option, it is their responsibility. So they will, in second option two, so they will mention that taxpayer can approach to US tax court. So if taxpayer want to see this issue in the court, then he can see. But for that, again, 90 days time we have. 90 days. So within 90 days, he must respond. Either he need to pay the 11,000, or he can approach to US tax courts. So this option is there in the notice of deficiency. Just getting this point?
Yes, Jay.
Yes. So option one, which is appeal within the IRS appeal. So this is not a court. So the first one, option one, which is appeal within the IRS. Within IRS appeals. So in this, usually, is it a court? No, it is not a court. So no court, and which is informal, which is not a formal, which is a kind of settlement, right? So which is informal. And in that case, whatever the discrepancy we have, so the difference between taxpayer amount and as per the examination department argument, so there is a difference amount, right? So do we need to pay immediately? No, we no need to pay immediately. No need to pay tax first. So we can argue. So taxpayer and IRS can argue there, and they will conclude one thing. If they are not agreeing within 30 days in the IRS appeals, then notice of deficiency will be there. So they can see the issue in the US tax court. So this is option one. Option two, which is go to US tax court. Go to US tax court. So in this, how many days, guys? So in the first one, how many days we have from the date of notice?
For appeal, it's 30 days, and for deficiency, it's 90 days.
So go to US tax court. So we must file, the taxpayer must file within 90 days. Within 90 days of notice of deficiency. Notice of deficiency. notice of deficiency. And also, do we need to pay taxes now? So no need to pay tax now. So this is very important. Again, we will see. So in other courts, we need to pay tax first and then we need to argue. But in these two options, we no need to pay any taxes first. So let's argue, and if it is fine, then taxpayer will not pay. If taxpayer loses the case, then taxpayer will pay. So that is different. But now initially we no need to pay any taxes initially. And also court decides this dispute. So in this case, the court decides the dispute. But previous case, appeal department will, decide the dispute. And do we have any other option? Like let's say we have done with option one. So here also taxpayer lose the case. Taxpayer lose the case here, and here in US tax court also taxpayer loses the case. Now, do we have any other option? Yes, we have option 3. Option 3, which is US district court or court of federal claims. So we have option which is US district court or court of federal claims. Court of federal claims. So why federal? So because this entire EA paper 1, 2, 3 majorly on federal taxes, not for state or local taxes, right? So that's the reason here we are talking about federal claims. And US tax court, US district court are federal claims. So in that case, taxpayer must pay the amount first. So taxpayer must be paid first. Taxpayer must pay the due first, then they can argue. So then they can, whatever the discussions taxpayer and IRS having, so they can discuss there. So after that, let's say in the previous one, the IRS asking to pay $11,000, right? So this is the issue, right? So taxpayer must pay 11,000 first, and then he can request for refund. So if taxpayer win the case, then he can get the refund. If taxpayer loses the case, then he will not get any refund. So that is there in the tax court. So tax court, district court or federal court. So first he need to pay. Just 1 second. Sorry. And taxpayer first need to pay the amount, and then taxpayer, then he will sue to the IRS, and he sue for what? Sue for a refund. So this is option 3. So now in the exam, you may be having this kind of questions like in which case taxpayer need to pay the due amount first. So they will give you options. So they will give you option appeal and also tax courts and district court and also Supreme Court. So in that case, when they need to pay the due amount first. So IRS appeal. IRS appeals. Do we need to pay tax first? Guys, do we need to
No.
pay tax first?
No.
And US tax courts?
No.
No need to pay. And also district courts?
Yes.
Yes, we need to pay. And also court of federal claims?
No.
We need to pay first. So then we can argue. And also when we file any appeal, so whatever the usually if you are not paying the amount within the due date, then we have to pay interest and penalties, because this is interest and penalties definitely will be there.
1 minute, Jay. In this US tax court, it should be yes, right? Because we will file notice of deficiency.
No. Here they need to pay. Only in the district court and court of federal claims they need to pay first.
Okay.
Even though it is a court, they will send a notice of deficiency, everything. But they no need to pay the tax amount first. So they will pay tax only in case if the taxpayer approaching to district court or court of federal claims, then he must pay the amount first. Okay, and let's say taxpayer IRS examined the taxpayer return and they decided they proposed an amount of $11,000, which is tax liability. So now in this case, taxpayer filed taxpayer appealed in the taxpayer appealed in the IRS appeal department. In that case, they determined on December 2nd. So penalties and interest will calculate from the date when they determine the tax liability. So even though we have filed an appeal in the appeal court, it doesn't matter. So we still, the penalties and interest will be from the date of notice, or from the date of actual tax return. Like it will be from April 15th. So from that period, these interest and penalties will still continue, even though we filed in the appeal. So it doesn't matter. Appealing a case generally will not stop any interest and penalties. They still continue to accrue until we pay the tax liability, or until we win in the appeal and receive no change in audit. So here important key: appealing a case doesn't stop. Appealing a case usually will stop any interest and penalties. No, it doesn't stop any penalties and interest. So we must pay penalties and interest. So this will continue until we pay the tax liability, until we pay the tax liability, or if we win the case, then we no need to pay. So if taxpayer win the case, then, and also he will receive. So once a taxpayer win the case, then he will receive one note, one statement from the IRS, which is no change in audit. No change in audit. So in that case, we no need to pay any tax liability. The interest and penalties will stop there itself. So which means we no need to pay any interest and penalties. So this is very important. Appeal usually will change any in a kind of, I mean, will give any abate for interest and penalties, guys. So if he appeal in this any of the courts, or if you appeal in the IRS appeal department, will it stop from paying penalties and interest, guys?
No.
No. So important key to remember: appeal doesn't normally abate penalties and interest. Abate means, which is kind of relief. So you cannot get any relief from paying penalties and interest. So this is very important, this point. Okay. So no change in audit means, which is IRS accepted the taxpayer position. That means previously what happened in the example, like let's say this is as per tax return and this is as per IRS, right? So when we appealed in the appeal department, the appeal department saying taxpayer position is correct, so there are no changes. So in that case, IRS also will accept the taxpayer position and no additional tax due. So here they are asking to pay the 11,000, right? So in case of no change in audit, you no need to pay any additional taxes and no need to pay any penalties and interest. So that will stop there itself. So that is the meaning of no change in audit. So no change in audit means IRS accept the taxpayer position, and also no additional taxes, and also no interest and penalties. So this is best possible outcome usually the taxpayer will expect in the appeal, right? And also usually appeal is the best option. So because in the appeal cases, like 90% of the cases will settle in the appeal itself. So not in the courts, and not in the tax court, and not in the federal claims or district court. 90% of the cases will settle in the appeal itself. Okay. And also we have seen examination, like we appeal. Okay, we'll start with one more topic we have. Okay. So once IRS examines, so after examine, so they will send a bill, right? So in the bill we have two options. One is proposed changes, and proposed amount, and also uh, they will give you an option which is appeal department, right? So within 30 days. So in that once I examination ends, once examination ends, in that case they will send a copy, so which is RAR, which is revenue agent report. So usually examination will be done by the revenue agent, right? So RAR, so they will send a report actually. So copy of RAR, which is revenue agent report. And also in that they will with the 30 days letter we have, right? So the 30 days letter contains 30 days letter, it should contains the first one, notice of the taxpayer right to appeal. So this they have to mention right to appeal within 30 days. They specifically have to mention this. And also RAR report, RAR report, and also agreement or waiver form, agreement or any waiver form, and also this appeal right, so this is a right to the taxpayer. So who had given this, there should be some provision in this tax code, right? So for that we have a publication 5 we have. So publication 5 for your appeal right. So they should mention everything in the 30 days letter. Who need to mention? The examination department should mention all these in the 30 days letter, which is IRS duty. So these points they specifically have to mention in the 30 days letter. One is notice of the taxpayer right to appeal within 30 days, RAR report and agreement or waiver form, and publication 5 information they specifically have to mention, which is for publication 5 for appeal rights. So publication 5 you have to remember. So whenever you have publication 5, which means this is the taxpayer right, appeal rights. So appeal rights we can see in this. And also, so in the 30 days letter, what are the options we have? So option 1, accept the proposed changes. And so if you want to pay option 1, if you want to go with option 1, so then you have to sign the agreement. You have to sign the agreement, and also what are the taxes is assessed. So you must pay the tax amount, and also the case close there itself. The case will close. Case is closed there itself. So this is option 1. So option 2, so if you don't want to agree, and then you can request review with the IRS appeal office, and which is independent from examination department, right? We already know IRS appeal office, which is independent office from the examination department. So in this case you can request review by the IRS appeal office. So this is option 2, right? And also IRS appeal office, like we once we file the case, then they will make a conference between taxpayer and between IRS. So IRS examination department. So how this conference can be done? So it can be in person. So this conference can be in person. This can be in person, or it can be via telephone, or it can be any correspondence. So correspondence, which means through mail communication. Also mail means, which is again physical mail. So correspondence. So it can be done in all possible ways. So either taxpayer can attend, or taxpayer, if taxpayer would like to make a representative, so he can use his either taxpayer directly, or either taxpayer directly, or he can use the representative. So these two options. So representative, in that case, how a taxpayer can represent, how another person can represent on behalf of taxpayer. For that, we have a form which is 2848, right? Power of attorney. So who can represent a taxpayer in this appeal? So who can represent, guys? We have already seen, right? So who can represent?
Enrolled agents,
Who can represent
CPAs,
before IRS?
attorney.
So EA and
Yeah.
CPA and also attorneys, they can represent before before in art appeals everything. So and also unenrolled preparers can represent unenrolled un these people we call it as enrolled agent, enrolled persons who are enrolled persons, who are enrolled preparers or representatives, which is enrolled agent, CPA and attorney. Unenrolled preparers, unenrolled preparers can you know uh, they can unenrolled preparers can represent before IRS? No. So only if it is witness, then they can go. But if it is representation, they cannot act. They cannot. They cannot act as a representative, right? So who will give the power to represent? So for that we have a form 2848, and taxpayer no need to represent directly. So he can represent someone who is enrolled preparer. And also we know small case. So what is the small case request, guys? So we have two appeal cases. We have two things, right? So one is small case. Yeah, small case request. So in this case, the amount tax disputed amount less than or equal to $25,000. So this includes taxes and penalties, not only tax liabilities, taxes and penalties, everything. So if the balance which is more than $25,000, less than or equal to $25,000, then small he can go with small case request. And in this case, we have to use a form number 12203. 12203, which is request for appeal review. So taxpayer must sign, and which is formal and which is no detail, which is simple information only, which we also call it as small case procedure. So small case procedure cases, what is the form? The form number 12203. The form number is very important in the exam. So small case procedure cases, form number 12203. And what about if the amount more than $25,000? In that case, taxpayer, which is the formal information which we have to give. So taxpayer identifying his information, which is taxpayer TIN number, and all this issued here taxpayer identity TIN number we have to give, and issue and facts and tax law supported and taxpayer position, everything we have to give. And also there is one more thing, declaration under penalties of perjury. So these also declaration also should be there. So declaration where we can see in the formal written protest declaration which is important. If taxpayer himself sign, so if taxpayer, here we have two options. So this declaration under penalties of perjury, which means like what are the facts and circumstances, whatever the document we are saying, so that should be as per their best of the knowledge. If they are trying to make any kind of fraud or something, then they need to pay penalties. So for that, this declaration statement is there. So if taxpayer himself sign, so if taxpayer sign cases, like he will be the responsible person. If enrolled agent also can sign. So first one, if taxpayer signs, if the agreement, the written protest signed by the taxpayer, then he only must sign these penalties of perjury. If taxpayer signs, then he must sign the penalties of perjury under. And what if enrolled agent signs? What if the statement, formal protest signed by the enrolled agent? So if the formal protest signed by the enrolled agent on behalf of the taxpayer, then enrolled agent having two options. So he need to select. So first option, EA personally knows the facts and true and correct, then he will select the first option. So EA personally knows the facts under the facts are true and correct. If interrogation personally knows, then he need to select this option. Or he do have one more option, which is he relies. So because he may not be knowing the facts and circumstances, right? So he usually may relies on the information provided by the taxpayer. So he must, sign. He must, in the declaration, he must mention all these points. Relies on information provided the by the taxpayer. Okay, this is clear. The declaration under penalties of perjury.
Yes.
Yes, right. And next one, what if taxpayer missed or ignored or no agreement which is raised within 30 days? So within 30 days the issue should be resolved. Within 30 days the issue should be resolved either through appeal or either directly by the taxpayer. So if within 30 days if no one is agreeing, then what will happen? So if taxpayer doesn't respond within 30 days or appeal cannot reach an agreement, so first one here in 30 days notice, so we have two things. One thing which is taxpayer didn't respond within 30 days. So taxpayer didn't respond within the period, within the 30 days. So this is one possibility. Another possibility, so taxpayer responded and he approached to the appeal, and the appeal the issue should be resolved within 30 days. So in the appeal cannot reach an agreement. Appeal cannot reach an agreement, which means no one is agreeing in the appeal. So in that case, what will happen? So if within 30 days, this should be done. So if not, then IRS issue a notice of deficiency, which is also called a 30 days letter. So this is 30 days. So next one, it will go to 30 days. So IRS will send a notice of deficiency, right? So notice of deficiency, which is, legal notice actually, which is a formal legal notice. So this is after assessing the tax return. So in this, what are the characteristics we can see in the 30 days notice of deficiency? The first one, it should be the IRS department should send this notice which is certified or registered mail. So usually while sending a mail, unregistered mails we can see, but this 30 days notice which is very important, right? So 90 days notice which is very important, right? So that's the reason the IRS should send the certified means which is by having all the trackers. So USA, many of the mails which are general mails, they don't have any tracking numbers, but this 30 days notice which is very important, that's the reason it should be certified or registered mail, like registered mail, like usually nowadays we are not using these postal cards, right? So for like there was a, I mean, there is a postal card. If you can write any information, you can just uh, in the card you can put the card in the postal something what we call postal box. So for that you will not get any tracking ID, nothing, right? So it will automatically will go to the recipient. So that was one option. Or another option, you can go to post office directly and you can register and you can send the post to the recipient. Like when we send a letter to the recipient, you will get acknowledgement, everything, right? So that is another post. So whenever IRS is sending 30 days notice of deficiency, it should be certified and registered mail only. So can they send any unregistered mail? No, they cannot do that because because this is a final notice, right? So that's the reason it should be registered as certified mail. And also they must state the amount of tax of deficiency. So they must state the tax deficiency amount. In the notice itself, they must mention everything. And also they must explain, so within 90 days cases, so 90 days later notice cases, what are the options available? So can they go to the again appeal? No, right? So 90 days later they will explain the right to petition in the US courts. So explain, it is the IRS duty, so they must explain right to petition in the petition with the US tax courts. So they also must explain everything. And if taxpayer out of USA, then instead of 90, so taxpayer can get 150 days, usually 90 days. If taxpayer is outside USA, then he will be having 150 days time limit. This is clear. And also if taxpayer files this timely petition, then so in this case, do we need to pay upfront? Do we need to pay in the tax codes initially? No, we no need to pay initially. And usually, practically, what will happen if you file a petition in the US tax court, again they will send the case to the appeal department. Many of the cases will solve in the appeal itself. So this is what practically will work. But because many 90% of the cases will not even see the trials as well. Trial means which they will see the facts and circumstances in the court, right? So 90% of the cases they will again send back to the appeal department itself, because that is easy processes, right? So court won't be having time to see your case so in detail, right? So that's the reason they will ask to resolve in the appeal department itself. Okay. And also, what if taxpayer misses the 90 days deadline? Then, so this is 90 days. Within 90 days, he need to approach to the US tax court. What if taxpayer misses the 90 days deadline? In that case, he having option. So whatever the deficiency taxpayer the US IRS sent, so that will be final. So deficiency becomes final here. Becomes final. There won't be any changes. Like here, IRS will send the notice of deficiency, and also they can argue in the US tax court. But if taxpayer misses this opportunity, 90 days notice, then whatever the deficiency we have, deficiency means the difference amount that will become the final. So taxpayer will lose all the rights. So the deficiency will become final, and IRS assess the tax. So IRS assess the tax. What exactly the IRS assess the tax means? Which means they will in their records they will report whatever the deficiency. Like let's say in the example we discussed $11,000, which is the deficiency amount between taxpayer and IRS. The difference we have, right? So they will record this 11,000 in their IRS records. So they will consider this is the final amount. So that means it is IRS having complete rights to collect the money from you. So which means SSD tax. And also taxpayer will lose the right. Which right he will lose? He will lose the US, I mean, tax court right. So taxpayer loses tax court rights. And also collection. So once IRS assess the amount, then they will start collecting. So they will send the collection department. So they will process, they will do the collection process. So collection action may begin. Collection action may begin, because they already assess the amount, right? So in the record they have recorded the deficiency amount. So IRS uh, will send collection department for collecting the tax amount. This is clear? Yes, no?
Yes, Jay.
Yes. Uh, so what is US tax code? So which is separate, which is a code for these federal taxes. So this is for federal courts only. So this tax code, so how the cases will be done in the tax code, we will see. So US tax code, usually which is a federal code, not for local or not for state level. So which is only for federal courts, and also which is separate from IRS. So the previous one, which is appeal department, we have seen, right? So appeal department under the IRS are separate from IRS. Guys, appeal department, IRS office of appeal, which is within the IRS or outside the IRS. This IRS independent office of appeal within the IRS or outside the IRS, guys?
Within IRS.
Within the IRS, but this tax codes outside the IRS. So the IRS won't be having any control. Like for IRS appeal department, IRS will send instructions, everything. So they need to follow IRM. So they do having internal revenue management manuals, everything. So they need to follow all the IRS instructions, but which is independent only from collection and examination, not from the IRS. So which is within the IRS, but here US tax codes are independent from the IRS. So that is one, characteristics of the US tax code. Okay, the US tax code, which is federal tax, federal codes only, and also which is separate from IRS. Separate from the IRS. And also this is exclusively which is in case which is tax laws only. So they only talk about tax laws. So they will not talk about any civil cases, or they will not talk about any criminal cases. So they will only and only discuss tax laws. So they are specialized and exclusively will take the cases with regards to the tax laws. It is only the court where uh, taxpayer can argue, or taxpayer can make his arguments without paying any taxes first. So other areas, so taxpayer need to pay first, which is other than US tax court, which is district court or any federal claim court. So then he need to pay first and then he can argue. But this is only the court, taxpayer will not pay any amount first. So without paying the tax first, he can argue in the IRS court without paying the tax first. And in the exam, what we have to remember, US tax code. So do we need to pay first? No, we no need to pay tax first. So when a taxpayer can go to US tax court, so what do we have any criteria for that? So we have a criteria. So usually, whenever you want to go to the court, no, you don't have right, whenever you want. So for this, we have two conditions. The first condition, IRS determines additional tax is owed. So first one, when we can have the right to approach to the US tax court, the first one, IRS determines for additional tax amount. IRS determines additional tax owed. And only that, no, apart from that, IRS issue notice of deficiency, which is 30 days later. Then only we can approach. So without notice of deficiency, can we go to US tax court? No, you cannot do that. IRS issue notice of deficiency letter, which is 90 days later. Deficiency notice of deficiency, which is 90 days later. So then only we can file a petition in the US tax court. So 90 days usually for the person living in USA. 150 days for the people who are living outside USA. Without a notice of deficiency, can we approach to the US tax court? Can we file a petition in the US tax court? Without a notice of deficiency, can we approach, guys?
No.
Taxpayer, the tax court has no jurisdiction. So the tax court will, the tax court will be having jurisdiction only if taxpayer receive a notice of deficiency, then only they will look for your cases. Cases where tax court is not available. So we understood cases where cases where tax court is available and cases where tax court is not available. Not available to the taxpayer. So first one, uh, refund cases. Usually, if you want to get a refund from the IRS, can we file any case in the tax court? Refund. Taxpayer want refund because he paid excess amount. So can he file any case in the tax courts?
No.
No, so he cannot do that. So taxpayer already paid the tax and is only seeking for refund. So in that case, refund cases, we cannot do that. So first one, taxpayer paid the amount already and he's seeking for refund. He cannot do that. So in that case, where he can approach? In refund cases, usually we have US district courts. US district courts, or you can go with US Court of Federal Claims. Court of Federal Claims. So in that case, he can file a petition. So, but in the tax court, he cannot file. Only for refund, no, he cannot do that. And also, so when a taxpayer need to pay first, situations which requiring payment before court review. What are the cases, guys? Situations where taxpayer make the payment first before court review. No one remember?
I think in district court.
Yes. So doesn't receive any notice of deficiency. So in that case, we can challenge with regards to the paid taxes or penalties or interest in the district court or any federal claim side. So in that case, we must pay the amount first, then we can, argue in the court. And so yeah, so this is one thing. And also types of court decisions. So how the court decision can, like, how they will deliver judgment in the court. So usually any of the court, not only tax courts, so any of the courts. So basically two types of decisions we have. One is regular decision, another one memorandum decision. So regular decisions and memorandum. Generally, many of the courts will give the judgment based on the previously ruled judgment. So, like, let's say, like in the movies or somewhere you might be watching, you might be seeing this, right? So we are giving judgment based on the some 2024 dated, some they will quote some cases. So based on that, they will give the judgment. Or if they're giving first time, then it, so two types of judgment. One is regular decisions, which means when they are giving first time, so they are giving the judgment, there are no backup or there are no, references in the previous cases. So in that case, which we called as regular decisions, which is first time the court rules on an issue, so then we call it as regular decisions. The court is giving first time, so on the specific issue, and also which whenever we have a new judgment, then it establishes the legal precedents. So when the court is giving any judgment for the first time, so then it will establish the legal precedent. So this is in regular decisions. And memorandum, basically court has already ruled or similar issue before. So previously court had given judgment, so now they are just applying the same rule for the existing or new fact. So in that case we call it as memorandum decisions. So memorandum decision means court has already ruled previously, which is similar issue before, and they are just applying the existing law to the new fact. So that is there in case of memorandum decisions. Okay, so two types of judgment we can say. So regular means new law issued or factual application. Regular means, guys, what is regular decision? Which means new law or existing law. New law, right? New law issue. And memorandum means existing. So which is factual application. Memo means which is factual application. They are just applying this previously ruled case, so with existing or new facts. So based on that, they are giving decisions. So not only US tax code, so this is in general, but specifically we are talking about US tax code. So that's the reason we have these terminologies, which is important. Regular decisions or memorandum decisions. And also, who can represent in tax codes? Like we know, so before IRS, enrolled agents, like enrolled preparer, enrolled representatives can represent before IRS. But US tax codes, who can represent? So for this, we have people we can classify into actually three actually. So first one, self. So who can represent? So this is important exam. Who can represent before US tax code? Represent before US tax code. So first one, self-representation. Taxpayer himself can represent. We call it as self-representation. Self-representation. Also, we pro SC. We call it as pro SC. So taxpayer himself can represent, and no professional requirement required. So because he is the one victim, right? So in that case, he can represent himself. No professional requirements, nothing. He no need to study any laws or nothing. And also another category, authorized non-attorney practitioners. So courts, we require attorney certification. So IRS, we require enrolled practitioners. If you want to argue in the courts, the person should be attorney. So without attorney, can we practice? No, we cannot practice. So US tax court, which is a court, right? So in this case, we require the people who are having attorney. So in this case, we can classify again the persons two categories. One is non-attorney practitioner and another one attorney. So non-attorney practitioner, non-attorney practitioners, and another one attorney. So attorney, so this is like he can practice anywhere in the any court based on his eligibility. So attorney, so no tax examination required, simply like he can practice. But non-attorney practitioners who are enrolled agents or CPAs, so what they can do? So like let's say we have a EA. So can he practice in the US tax court? No, he cannot do that, right? Because court is only for attorneys, but he is a non-attorney practitioner. So in that case, what he can do, the EA or CPA, there is an exam. So there is separate exam. So the US tax code, to practice before US tax code, he need to pass the exam. So he must pass, he no need to clear exam attorney. So attorney, we have different law subject, like he need to clear the exam, but he's an enroll agent already. He would like to practice before US tax code. For that, EA certification or CPA certification will be fine. Along with that, he must pass an exam, a separate exam. He must pass a separate US tax court exam. So he must pass that. So then yes, he must be formally admitted to practice. So he will be eligible to admit to practice. So that is there in case of non-attorney practitioners. So what about attorneys? So do they need to write any exam? No exam, no tax court exam required. No tax court exam required, because he's already enrolled practitioner. So why he require, why he need to write any exam? So not at all required. So practice before IRS, which is equal to practice before US tax court? No. So to practice before US tax court, we must pass a separate US tax court exam. So then he will be admitted to practice before US tax court. So with this, what we understood, so practice before IRS is equal to practice before US tax court. Both are one and same. So practice before IRS is equal to practice before US tax court. Yes or no?
Yes.
Sure. So who can practice before IRS? Enrolled agent, CPAs, and attorneys. We have seen these practice before IRS separate topic, right? So you can just watch the practice before IRS topic, then you will have idea. And now practice before us IRS, which is not equal to practice before US tax code. For that he need to write a separate exam, right? So that is what we have discussed right now. So he need to write a separate US tax code exam. He need to qualify for that. So then only he can practice before US tax code. So which means which is not equal to is not equal to which is not equal to practice before tax code. So practice before IRS is equal to tax practice before US tax code. Yes or no? The answer which is not equal to IRS, which means then answer yes. All right, this is clear. Guys, yes, no?
Yes.
Yes.
So usually how tax court resolved. So many of the cases I told you. So many of the cases they will refer back to the IRS appeal. So most of the cases. So once they file a petition, then they will refer back to the IRS appeal. 90% of the cases will solve without any trial. So very few cases solve settlement in common like in the US tax court. So this is how practically things will work. And also the taxpayer like let's say first one, IRS found that there is some issue, there is some discrepancy, like taxpayer don't have any proof for the expenses. So in that case, they will send a proposed bill, right? So which is 30 days later they will send. He taxpayer don't have any proof, but still he filed his case in the up in the appeal, and then appeal dismissed. So I taxpayer lose the case, and again he do have right to approach to the US tax court, and also he can approach to the district court. So we do have all the options, right? So taxpayer really don't have any proof for the expenses, but still he is delaying. He is using the delay tactics. So with that, he can pay taxes after after all the legal issues, right? So can he do that? So taxpayer really don't have any proof, but he filed a petition in appeal, and he filed a petition in the US tax court, and he filed a petition in the district court, and he went to Supreme Court. Can he do in this way? So if everyone is doing in this way, then IRS will end up from collecting taxes. So that is the big problem, right? So that's the reason taxpayer cannot show any cannot do any delay tactics. So even though you have a right to approach all this, but still you cannot. If taxpayer really know the factual information, then he cannot show any delay tactics, right? So so delay tactics are allowed or prohibited? Delay tactics are allowed or prohibited? So delay tactics are prohibited. So which means he should not do. So which is not actually allowed, right? So US tax code generally exists only to resolve the legitimate, and that too within the legal frames. They can resolve the disputes only. So they will not help in delay IRS collections. So when taxpayer is not paying the amount, IRS will send a collection team, right? But still you are using all legal possible ways to stop the collection. So it is a kind of delay tactics. So we cannot do that. Okay. So in that case, what will happen? So if taxpayer doing any delay tactics, using any delay tactics from paying taxes, then the court may impose a penalty of up to $25,000 penalty we have to pay. Up to $25,000 penalty. So this is straightforward question we can see. So what if taxpayer doing any delay tactics, so from collection from the IRS? So in that case, the court will impose a penalty up to $25,000 penalty for previous frivolous or delay tactics. So we have a phrase here in the exam. So penalties for frivolous or delay tactics. So in that case, how much penalty? So penalty which is $25,000. Right? Yes, no, anything?
Yes.
Yeah. So most probably like common frivolous arguments we have. So frivolous means which is, which is unfair. So common frivolous arguments usually, like many of the taxpayer, what they will do, they will argue income tax which is invalid, which is income tax which is unconstitutional. So they will argue these kind of statements. So which is not a valid. So income taxes which is valid, so which is constitutional, but still taxpayer will tell that income tax is invalid or income taxes which is unconstitutional, so which is legal or not. So the statements, which these statements we call it as frivolous arguments or frivolous statement. In that case, taxpayer may be imposed with penalty of $25,000 or any statement like common frivolous statements, which is income tax is invalid. Income tax is invalid. If taxpayer making any kind of statement, then which is the frivolous argument, in that case, he need to pay penalty of $25,000. He cannot do that. This was the case the Fed government had seen previously, the IRS had seen previously. So that's the reason they are making strict rules. So previously, like many of the taxpayer they were making statements which is income taxes which is invalid, are they making statements which is income taxes which is unconstitutional? That is not the case, right? So the income tax is valid, which is constitutional. So they cannot do those kind of statements. And also claims 16th Amendment, which is not ratified. So many things like uh, courts repeatedly rejected, even the court repeatedly rejected, but still he will file a case. So that is also not allowed. And argument, so they will do kind of arguments which is zero, any argument which has zero legal standing. Those also frivolous arguments only. So arguments having zero legal standing, having zero legal standing, which means you are arguing in the courts or in the appeals or anywhere, but there is no legal stand for that. So those kind of arguments we call it as frivolous arguments. So in that case, court will impose a penalty of $25,000. Okay. So paying taxes is voluntary or paying taxes usually, which is voluntary, right? So this is our duty. We have to pay the taxes. So we have to file your income tax return. So while we filing the income tax return, do we need to send all the proofs to the IRS? No, because income tax, any of the country income tax which is voluntary, which means self-assessment tax, which is what are the tax return you are filing, that should be best of your knowledge, and you should not do any you should not underreport, or you should not make any you should not do any underreporting. So that is there in voluntary uh, taxes, but still you may do any mistakes, right? So you may underreport anything, right? For that we have compliances department, so they will take care about the compliances part. Are some cases what the clients will argue, the taxpayer, I'm not a person under IRC code, so they will do these kind of statements. So or else they will make a statement, my income which is not taxable, so those are unconstitutional. Those are frivolous. So in that case they have to pay penalties. And also we have a couple of topics. So yeah, so I think two topics we have, so we will discuss those two topics in the tomorrow session. Okay guys, do you have any questions for me?